Colonial shadows in a constitutional republic. The persistence of laws discriminatory to Hindus written by Aditi Joshi. Colonial law reshaped India's religious, economic, and cultural life, yet its most enduring legacy is the asymmetry it created. Hindu temples remain under state control, while Waqf enjoys autonomy, revealing a discriminatory framework still embedded in independent India's legal system. British colonial rule sought to codify and regulate expansive domains of Indian social, economic, and religious life through the machinery of a centralized managerial state. The colonial legal strategy was twofold. First, it consolidated the coercive and extractive powers of governance by strengthening penal law, codifying police authority, and enacting comprehensive forest legislation that facilitated resource extraction while simultaneously criminalizing traditional livelihoods. These measures entrenched a disciplinary regime aimed at maintaining order and maximizing revenue. Second, it restructured indigenous institutions, most notably Hindu temples, by subjecting them to statutory schemes that transformed them into state-supervised public trusts. In sharp contrast, Islamic Waqf was recognized under Anglo-Mohammedan law as a protected and internally regulated religious endowment, thereby institutionalizing an asymmetry in the legal treatment of Hindu and Muslim religious property. These colonial choices have proven remarkably durable. Despite the constitutional transition in 1950, their logics continue to reverberate across contemporary statutes, administrative departments, and judicial precedents. The endurance of state control over Hindu temples, the privileged statutory framework governing Waqf, the survival of colonial penal provisions relating to religious offense, and the bureaucratic continuities in forest governance and community policing all testify to the extent to which the architecture of the colonial state has persisted, albeit in altered form, within the legal order of independent India. The colonial template for temple control and its modern avatars. The colonial-era regulation of Hindu temples reached a decisive turning point in the Madras Presidency during the 1920s, when legislation pioneered a framework that fundamentally altered the relationship between the state and Hindu religious institutions. The Madras Hindu Religious Endowments Act of 1926, followed by the 1927 amendments and commentaries, institutionalized the treatment of temples not as autonomous centers of religious life, but as public charitable trusts subject to state oversight. This legal architecture authorized the creation of a state-nominated board empowered to supervise temple finances, lands, and administrative practices. By subsuming religious institutions within a regime of charitable trust law, the legislation reduced the autonomy of temple communities and placed them within a managerial framework designed to reflect the imperatives of colonial governance. Subsequent statutes across different provinces and presidencies would replicate this model, thereby establishing a durable precedent. Following independence, the state of Tamil Nadu operationalized and expanded this colonial lineage through the Tamil Nadu Hindu Religious and Charitable Endowments, H.R.C. Act of 1959. Administered by a dedicated H.R.C. department, this legislation consolidated state control over an unprecedented range of religious institutions. The department's statutory remit today includes oversight of temple lands and immovable property, financial administration, the appointment of trustees and staff, and the supervision of rituals and festivals under the rubric of secular management. Policy notes and official departmental portals consistently frame this apparatus as one of guardianship and public accountability, thereby legitimizing continued state intervention in domains historically governed by religious communities. The scale of this apparatus is striking. Government sources and departmental listings indicate that the Tamil Nadu H.R.C. department currently administers over 36,000 temples, in addition to numerous mutts, endowments, and charitable institutions. This figure illustrates not only the bureaucratic reach, but also the normalization of state management over Hindu religious life. What began as a colonial experiment in the Madras Presidency has thus evolved into one of the most comprehensive regimes of state supervision of religion anywhere in the democratic world, raising enduring questions about constitutional guarantees of religious freedom and the asymmetry in legal treatment vis-a-vis other communities' religious endowments. Constitutional tension and the Shire-Mutt doctrine. The constitutional framework and its early judicial interpretation critically shaped the trajectory of state control over Hindu religious institutions. Soon after the constitution came into force, the Supreme Court in the Commissioner, Hindu Religious Endowments, Madras vs. Sri Lakshmindra Tirtha Swamiyer of Shire-Mutt, 1954, delivered a landmark ruling that remains foundational to Indian religious jurisprudence. The court articulated a doctrinal distinction between matters of religion, which fall within the protective ambit of Articles 25 and 26, and secular matters associated with the administration of property, which the state may legitimately regulate. In striking down parts of the Madras Hindu Religious and Charitable Endowments Act, 1951, the judgment reaffirmed the autonomy of religious denominations in matters of doctrine and ritual. At the same time, however, it upheld the state's competence to oversee the secular administration of temple property, thereby entrenching an administrative foothold that has since expanded into comprehensive bureaucratic oversight. The constitutional text itself is ambivalent. Article 26b guarantees every religious denomination the right to manage its own affairs in matters of religion, while Article 26d confers the right to administer such property in accordance with law. The latter clause, particularly the phrase "in accordance with law," has been interpreted as an enabling provision, allowing legislatures to impose extensive regulatory regimes over Hindu temples and endowments. In practice, this textual opening has functioned as the jurisprudential gateway through which HR and CE-style legislation has survived successive constitutional challenges. Crucially, this model of control has been applied asymmetrically. While Hindu institutions have been placed under the purview of specialized statutory departments exercising expansive authority, no equivalent state-run machinery exists for the administration of churches or mosques. Christian and Muslim institutions retain a greater degree of autonomy in managing their internal property regimes, safeguarded under the Waqf Act and denominational self-governance of churches, respectively. The result is a constitutional paradox. A provision designed to secure denominational autonomy has, through judicial interpretation and legislative practice, become the foundation for the continued state management of Hindu religious institutions, reflecting both the colonial legacy of public trust regulation and the selective application of constitutional guarantees. Asymmetry by design? The Waqf exception and its expansion. Colonial recognition of Waqf. In contrast to its interventionist approach toward Hindu temples, the colonial state adopted a markedly different legal strategy in relation to Muslim religious and charitable endowments. The Mussalman Waqf Validating Act of 1913, followed by supplementary enactments in 1923 and 1930, regularized and fortified the institution of Waqfs as a distinct legal form. These statutes overturned earlier judicial skepticism, particularly the Privy Council's disapproval of family-oriented Waqf al-Walad, by explicitly validating Muslim family and charitable endowments as legitimate religious trusts under Anglo-Mohammedan law. The 1913 Act thus recognized Waqf as a protected juridical category, embedded in Islamic jurisprudence, and insulated from the forms of bureaucratic restructuring applied to Hindu endowments. The management of Waqf properties remained within the domain of Muslim trustees, mutawalis, and later, statutory boards constituted to represent community interests, rather than being absorbed into the machinery of the colonial or post-colonial state. While the 1923 and 1930 amendments introduced measures for registration and supervision, they reinforced the principle of internal community governance rather than transferring authority to state departments. The legal recognition of Waqf thereby entrenched in asymmetry. Hindu religious institutions were gradually reclassified as public charitable trusts subject to administrative oversight, while Muslim endowments were validated as autonomous religious institutions managed within the framework of Islamic law. This differential colonial codification has had long-term effects. Independent India inherited not only the HR and CE model for Hindu temples, but also the legally fortified Waqf system, which the Waqf Act of 1954 and subsequent revisions in 1995 and 2013 expanded into one of the largest systems of religious landholding under autonomous boards. The juxtaposition highlights how colonial policy choices, one of bureaucratic absorption and the other of juridical validation, produced enduring asymmetries in the governance of religious endowments across communities. Post-independence consolidation. Waqf Act, 1995 and 2025 amendments. Independent India extended and centralized the colonial legacy of Waqf recognition through the Waqf Act of 1995, a comprehensive statute that consolidated earlier enactments and created a multi-layered governance structure. The act established the Central Waqf Council, chaired by the Union Minister for Minority Affairs, and mandated the creation of state Waqf boards with extensive supervisory powers over the registration, management, and protection of Waqfs. These boards were vested with quasi-judicial authority to oversee the appointment and removal of mutawalis, to safeguard endowed properties, and to adjudicate disputes relating to encroachments and alienation. The Act thus entrenched a statutory regime that not only preserved the autonomy of Waqf from direct state management, but also enhanced its institutional resources under community-governed frameworks. Parliamentary developments illustrate the dynamism of this regime. The Waqf Amendment Bill, 2025, introduces additional provisions concerning digital land records, dispute resolution mechanisms, and oversight of the board's functioning. While the bill has faced judicial scrutiny over its potential implications for property rights and minority governance, its trajectory underscores the state's continuing commitment to refining rather than dismantling the Waqf system. Official texts, India Code repositories, and government briefings highlight the evolving statutory architecture, while contemporary reporting places the scale of Waqf's assets at hundreds of thousands of registered properties, spanning millions of acres nationwide. This makes Waqf one of the largest institutional landholders in India, an endowment class whose colonial-era legal validation has been robustly preserved and expanded under post-colonial law. The net effect is a structural asymmetry in the governance of religious endowments. Hindu temples, in many states, remain under direct state management through HR and CE-style departments, where bureaucratic control extends to finances, land, and administrative appointments. By contrast, Waqf institutions operate within a bespoke, community-governed statutory framework, enjoying autonomy of management under the supervisory umbrella of Waqf boards. Both systems bear colonial origins, one born of reclassification and bureaucratic absorption, the other of juridical validation and protection. Yet their divergent trajectories in independent India, one toward state capture, the other toward community self-governance, continue to shape the contemporary politics of religious freedom, property rights, and constitutional equality. Criminal law, outraging religious feelings from IPC 1927 to BNS 2024-25, the colonial birth of IPC Section 295A. The addition of Section 295A to the Indian Penal Code in 1927 must be read against the backdrop of the Ranhila Rasool controversy, where provocative religious pamphleteering triggered widespread unrest. The colonial government responded by enacting Section 295A, criminalizing deliberate and malicious acts intended to outrage religious feelings. This was not merely a neutral expansion of penal law, but a targeted, speech-restrictive provision designed to contain communal volatility by policing intercommunal insult. Scholarship underscores its function as a tool of pacification rather than principle, embedding a logic of censorship into Indian criminal law that persists to the present. The new Penal Code, BNS Section 299, India's criminal law overhaul, culminating in the Bharatiya Nyaya Sanhita, BNS, 2023, replaced the IPC, effective 2024. Yet, in substance, the colonial-era blasphemy provision has survived intact. IPC Section 295A was recodified as BNS Section 299. Comparative tables issued by state police and training academies explicitly map this continuity, noting only cosmetic drafting updates. The BNS also recasts IPC Section 298 as BNS Section 302, thereby retaining the prohibition against insulting religious beliefs through speech or gesture. The persistence of these offenses reflects the tenacity of colonial design, a communal order logic of religious insult, now transposed into Republican legislation. Contemporary scholarship warns of the risks: selective enforcement, chilling of legitimate expression, and majoritarian/minority asymmetries associated with this continuity. The Indian Forest Act, 1927 expropriation as policy. The Indian Forest Act of 1927 consolidated earlier ordinances to vest expansive powers in the colonial state over reserved and protected forests. The statute criminalized customary access and delegitimized traditional uses, displacing pastoralists, tribal groups, and communities whose sacred groves were reclassified as state property. Though the Scheduled Tribes and other traditional forest dwellers, Recognition of Forest Rights, Act, 2006 sought corrective recognition of customary rights, the 1927 framework remains in effect. Its presumptions continue to shape enforcement manuals, bureaucratic discretion, and recurring conflicts over access, thereby reproducing colonial forms of ecological governance. The Criminal Tribes Act, 1871 repealed statute, living stigma. Few colonial statutes epitomized the criminalization of identity more starkly than the Criminal Tribes Act, 1871, which declared entire communities as hereditary criminals. Subject to registration, surveillance, and restrictions on movement, such groups were legally stigmatized across generations. Although the act was repealed in 1949 to 1952, it was replaced by the Habitual Offenders Act, which carried forward aspects of the same logic. Scholarship documents the endurance of stigma, with denotified and nomadic tribes continuing to face disproportionate policing and social exclusion. Recent state commemorations of Denotification Day reflect an ongoing, if halting, reckoning with this colonial injustice. Education policy as cultural engineering. Colonial interventions in education policy exemplify a subtler, yet equally consequential form of legal and cultural engineering. Macaulay's Minute, 1835, and Wood's Dispatch, 1854, explicitly shifted state patronage away from Sanskrit, Persian, and vernacular traditions toward English language instruction. The objective was to cultivate an intermediary class, loyal to colonial governance and alienated from indigenous epistemologies. This anglicized template has had a remarkable afterlife. Debates over curricula, historiography, and language policy in independent India still revolve around the Macaulay-Wood lineage, with the state serving as the arbiter of cultural transmission. A post-colonial paradox. Articles 25 to 26 versus colonial governance modes. The Indian Constitution enshrines freedom of conscience, Article 25, and denominational autonomy, Article 26. Yet, in practice, administrative continuities reproduce colonial governance logics. HRC-style regimes keep Hindu temples under state departments, while Waqf institutions enjoy community-led autonomy under a statutory framework preserved and expanded since colonial validation. Penal provisions rooted in colonial communal management, now BNS Section 299-302, continue to chill expression. Forest law remains tethered to 1927-era expropriatory presumptions. Even judicial interventions, beginning with Shirer Mutt, 1954, while protective in part, legitimize state oversight of the secular administration of Hindu property, thereby entrenching a regulatory asymmetry unmatched in the governance of churches or mosques. Policy options and reforms restore denominational autonomy for Hindu temples, parity principle. Amend HRC-style laws to vest management boards in devotees/denominations, with transparent auditing. Reserve state intervention only for narrowly defined fiduciary failures, thereby aligning temple autonomy with the self-governing model long accorded to Waqf. Rationalize endowment laws across religions. Move toward a neutral, uniform endowments code, featuring routine fiduciary duties, audit standards, and protections from encroachment, without requiring day-to-day bureaucratic management. Revisit BNS Section 299, XIPC Section 295A. Narrow the offense to imminent incitement or violence standards, pruning vague formulations that invite selective enforcement, and aligning it with constitutional speech protections. Modernize forest governance with rights-first implementation. Prioritize the Forest Rights Act, community forest management, and recognition of sacred groves. Sunset or substantially amend 1927-era presumptions. Complete justice for denotified/nomadic tribes. repeal residual habitual offenders frameworks, and fund rehabilitation, documentation, and stigma reduction initiatives, acknowledging the unique harms of the CTA. India's constitutional vision of religious freedom and equality sits in uneasy tension with the afterlives of colonial law. The persistence of HRC regimes that subject Hindu temples to micromanagement, the parallel preservation of Waqf as a privileged and autonomous endowment system, the transplantation of colonial-era blasphemy provisions into the Bharatiya Nyaya Sanhita, the endurance of forest governance structures rooted in expropriation, and the lingering stigmatization of denotified tribes all testify to the resilience of a colonial legal habitus within a formally republican framework. These continuities underscore not merely administrative inertia, but a deeper structural paradox, a constitution that promises denominational autonomy and civilizational plurality coexists with laws that reproduce colonial asymmetries of control and recognition. A principled reform agenda is thus imperative. Anchored in the values of parity, autonomy, and constitutionalism, such an agenda would restore genuine denominational self-governance to Hindu institutions, rationalize the law of endowments across communities, recalibrate speech offenses in line with constitutional standards, and dismantle frameworks of dispossession and stigma inherited from the Raj. Only by disentangling these legacies can Indian law align more authentically with the civilizational diversity it purports to safeguard and move beyond the shadows of colonial governance toward a jurisprudence rooted in the promise of the Constitution itself.